The duty of confidentiality is to be enjoyed by all classes of patients, of people who visit us in the hospital. Whether the person is a celebrity, a child, an adult, whatever. Even a criminal from the prisons who come to us is supposed to enjoy confidentiality.
Hello there. Welcome to another episode of The Lowdown here on GhanaWeb TV. My name is Echi Atisu. Today we have a very interesting conversation on medical confidentiality. We want to discuss whether or not there is a thin line between that and, of course, the law. When do you decide as a health practitioner, for instance, to share confidential information with somebody other than your client? And is there a law that can override that? Well, we have the right person, the best expert, to be able to help us understand this topic more and more. Dr. Edward Adodankwa is a lawyer. He's also a doctor, and he's our guest on this episode of The Lowdown. Doc, you're welcome to our studios.
Thank you very much. Thanks for
having me. I hope you're doing very well.
I'm doing great.
Wonderful. Now, this whole issue of medical confidentiality, especially for a part of the world, is that something that a lot of people know about? First of all, what is medical confidentiality?
Thank you very much. Confidentiality is very important in Medicare. Medical confidentiality is this duty not to disclose what a patient has shared with you to unauthorized third persons without the consent of your patient. This is what is able to give our patients the confidence to approach us, to be able to say all the right things without hiding anything. And by this, we are able to put the pieces together, make accurate diagnoses so that effective treatments could be given. So it is very important. Once it's abused, once patients do not have trust in what they are coming to tell us, that it will remain confidential, they may not come, or they may hide some of the things, and that could impede care.
You say unauthorized. Who are those kinds of people who are authorized? Who gives the authorization? Is it from the doctor's point of view, or is the patient or the client per se?
The information is about the client. The information is coming from the patient. So if you are to break confidentiality or you are to release that information, it should be with the consent of the patient, not the clinician's perspective, but the patient. You may recall recently the Kwame Eugene case where he was admitted to UGMC,
yes.
And later we were told a staff there, though later it's being discounted, came out to put the information out there, and you saw the public uproar because it is not expected of a doctor or health personnel to come out with such information. But if when it came from a journalist, we hailed the journalist, and Ajafo was hailed for even assisting with them and all that. When the journalist comes out with such information, they are hailed that they were fast, they were able to get a scoop. But if it comes from you, a health worker, it means the message you are sending or the signal you are sending out there is that for all those coming, your information may be released to the public, and that may affect the confidence of care.
But we're also in an age of technology. There's social media and a lot of all the things that goes on online. Now you walk into my health facility, I have my phone, and I see this and I just share it. Is that illegal? Is that wrong to do, even for a health practitioner?
It is immoral, it is unacceptable, and it's against our ethical codes. What a general person may do may be unacceptable when it comes from a professional. In fact, some of our leaders, ex-ministers and co, who told me that at times they go out there to seek health care, not necessarily because Ghana, we don't have competent people to handle it, but sometimes they think their information may not be handled confidentially.
Right here at home?
Right here at home.
Oh, okay. But now there's also the issue of confidentiality and privacy. Are they the same? And where do you go beyond privacy to be able to give out something that's been shared with you in confidence?
Privacy and confidentiality has been used interchangeably, but legally they are different. With privacy, it is this right to prevent all others from intruding into your private space or personal space or having access to your personal information, and that is guaranteed under the Constitution as well. But with confidentiality, the person has already shared this private information with a professional. Maybe the person went for confession with a priest, he has shared the information. The person came to a doctor, he has shared the information. The duty of confidentiality says, you, the professional who has received this personal information in the course of your work, you do not share it with a third person or a third party without the consent of your patient. That's the difference between confidentiality and privacy.
So it means that, but I am a little confused because people who are in public office especially, and we'll get to talk more about that, because that's where most of the time you hear people ask, what happened to this leader? What happened to that person? Now you're a public official. Is your life always private, even medically, that the citizens should not know about what's happening to you? That's
a very interesting question you've asked. The duty of confidentiality is to be enjoyed by all classes of patients, of people who visit us in the hospital. Whether the person is a celebrity, a child, an adult, whatever. Even a criminal from the prisons who come to us is supposed to enjoy confidentiality. There are exceptions where we can break confidentiality. I'm sure we will get there. But a public person is supposed to also enjoy confidentiality. And I will cite the case of Naomi Campbell versus the MGN case. Campbell is a supermodel. She's out there. Her life is out there. But she was attending this Alcohol Anonymous meeting, which is for people suffering all sort of addictions. And she had even covered her head to avoid being detected. The paparazzi picked it up, they took pictures, and it was published. Now she's sued for a breach of confidence. Now the general idea would have been for a celebrity, your information being out there should have been normal, as we normally say. But the law courts made some profound statements. They said that when it comes to health information about a person, it's to be treated as private and confidential.
All the time?
Even with a celebrity. You're asking all the time. There are exceptions. And the exceptions, that's you breach it when there's a need to protect others from being harmed. You may breach it when the law requires you to do so. But anytime personal information like that come in conflict with the right of publication or free press, depending on the nature of the information. In Naomi Campbell's case, what the court said was that people trying to come out of addictions need support. They need affirmation. They need encouragement. If you publish such information, you take them steps back.
Okay.
And therefore, it was ruled in her favor that for health information, it should be treated as private and confidential. Again, depending on the nature or the kind of information we are talking about.
So when can you actually, maybe lawfully, break the medical confidentiality code? When can that actually happen?
Thank you. So confidentiality is not absolute. There are exceptions.
Okay.
And before that, let me bring in the issue of privilege. There is medical confidentiality, but there is no medical privilege. The difference is, for privilege, when you say something is privilege, even the law courts cannot compel you to, release the information or to talk about them. But for medical confidentiality or for medical information, you can be compelled to release them on the authorities of the court or on the authorities of law or any legal institution or lawful institution empowered to do so. And it may even include the police, the Nursing and Midwifery Council, the General Medical Council. They can compel you to review information. Now, there's the most important aspect of public interest. At times, it is in the interest of the public for you to release certain information or for you to reveal some information so that others can be protected. Outside the case of the Tarasov versus the Regent University case, a gentleman approached a young lady. The lady refused his advances. He developed some mental health issues and approached a psychiatrist or a psychotherapist. And he revealed to a psychotherapist that he wants to kill the girl for the girl refusing the proposal.
So he said it's in confidence to the
doctor, to the psychotherapist. Okay. Now, is he to reveal this information or not? If he doesn't, somebody's life is on the line.
He may referring to the medical practitioner here.
Exactly. That's the dilemma in which he found himself. But the issue is also confidential. because it's your patient you are talking about. He informed even the police. So they detained the gentleman, but he did not inform the young lady or her family. So after the gentleman he was an Indian graduate student. After he was detained briefly and he appeared okay, he was released. But he went to befriend the family.
Of the lady?
Yes, the lady's brother. So which got him closer to the family. If the doctor had revealed the information or notified the family, they would have taken precaution. Because this didn't happen, he got closer to the family. Within a month of making that threat, he killed a girl. Tatiana was killed. So they were found negligent that they should have informed the family or the young lady herself. Mm. So here, you break confidentiality to protect others. And this is backed in our criminal code as well. The duty to prevent significant harm. A similar thing happened in the UK as well. Mm. A gentleman had killed about 5 of his neighbors. That's the W versus the Dr. Egdel case. And he was, taken in. In fact, he was even charged for murder, but later it was stepped down to manslaughter when he pleaded diminished responsibility. So he was sent to a psychiatric institution. Now, at a point, they wanted to release him. So they engaged a private psychiatrist to evaluate him. And the doctor found out that the guy is still dangerous. So they took down that request to get him out. But later, there was going to be another review. And the doctor thought this time, if he doesn't act to inform the Ministry of Interior, the Home Office, they may proceed with that review without his report, because they had not tendered his report. So he breached confidence, or he even breached contract by informing the Interior Ministry or the Home Office, in the case of the UK, and they took action to prevent him from being released. So the guy sued for breach of confidence. And it was said that what the doctor did was in the interest of the public, to protect elements of the public. So confidentiality can be broken when there are such dire consequences if you do not act.
So where does a case like that of our late former president, the late John Evans Atta Mills, he was sitting president and he died. Up to now, we don't know exactly what killed our former president. In such a situation, with those who are asking, for instance, that we want to know what killed our president, what was really going on with him, and we don't have answers, can you get the court to compel such an information to be given out just for public interest reasons?
Now, President Mills, at his age, and given the kind of condition he was having, the sort of treatments he had, I would even say he was blessed. And he even lived longer than the average expected, for people who had his kind of condition. That doesn't mean somebody should harm him. Mm-hmm. But health information is confidential. The Right to Information Act says so, affirms that. Our Data Protection Act equally says so. Now, when a person dies outside the hospital, our Coroner's Act says they should be given to the coroner. Autopsy will be done, and if there is any basis for criminal charges or to take actions in those directions, it will be done. These things were done in the case of Prof. Mills, and the family has affirmed they've received the autopsy report, and they did not indicate there was anything that was criminally incriminating. Okay. So we take it as such. And I think the other informations out there have not been compelling or strong enough to compel any other action by government to look into it or otherwise. I'm sure Kadma Mills and the family, they are very strong people, they would have come out. But until they do so, it remains confidential and we can't move into it. And I would even say that the man led a very great life. He's been good, he's been fine, and in the interest of his legacy, I think we could leave it there, unless really there are compelling reasons or compelling facts out to suggest otherwise.
So what about before someone dies, and then maybe before the person dies, puts something on paper and says that I want my people to know this, much as this has been shared in confidence. When we return from the break, we'll let Dr. Adodankwa answer that question for us. We're back from that break, and I asked a question before we went on the break. Doc, now somebody shared information with you in confidence, but before the person dies, writes maybe down that please share this information with my family. Is that a situation, for instance, that would allow a medical practitioner to break the confidentiality and share with maybe other people like family?
Thank you. Now, as we've established, you do not breach confidentiality unless there are compelling reasons to do so, or the patient has agreed for you to share the information. The wishes of a patient should be respected unless it's rebutted by the public interest reasons or a request by an institution of law or the courts or those exceptions. If a person says, don't reveal what my condition is or my diagnosis, by default, it should be respected. But you realize that if, when a person dies, we issue death certificates, and that is an instruction of law. And the wishes of a person will not override that. So if the very diagnosis he doesn't want to come out happens to be a reason of his death, then that one by law we are supposed to disclose. And we will disclose that.
But how about when it is not?
When it's not, then you don't. When it is not, because you reveal only what is necessary. If the person has HIV and says, I don't want my family to know, that's fair. If the person died of an accident, you don't still go and add the HIV there. It's unnecessary. You reveal what is minimally necessary.
It means that even in death, the confidentiality works even when you are not around.
Exactly. The Geneva Declaration has said it. The modified Hippocratic Oath says so. A person's right to confidentiality outlives even his death, and it should be respected, like we started the case of Prof. Mayos. It should be respected. I recall the case of the late French President Mitterrand, Francois Mitterrand. Yes, his doctor, his personal doctor, tried publishing a memoir to reveal the struggles with cancer the late president had while he was on the seat. In fact, his estate injuncted him, the doctor. And when he was reported to the legal council, the medical council in France, he was banned even from practicing. And he was fined heavily for that breach of confidence. It was much later that even the book was stopped from coming out. But it was much later that the European Court of Human Rights said, enough for the punishment, at least the book may be released. So yes, deaf people still have their right to confidentiality until the lawful exceptions kick in.
Now, how do health practitioners actually balance these two things? I'm asking this because sometimes the weight of keeping people's information confidential, how do you balance the two and make sure that you are keeping your sanity as well as keeping your trade going so that you don't lose your license, things like that? How do you balance it?
This is very important. There's a balancing act to be done as confirmed in the ABC versus St. George's Hospital case, because there is no fixed rule that disclose breach confidentiality or don't breach. You consider each case on their basis, case-by-case basis. You consider the factors at play, and that will inform you whether there's a need to breach confidentiality, especially if it's in the public interest or it is necessary to protect somebody, like I cited the Tarasov cases. Now, there are other cases where the court felt it's not necessary to breach confidentiality, because when you breach it, the harm caused is far outweighed, or sorry, the benefit to be gained when you breach is outweighed by the harm caused. There's a case of X versus Y. Two doctors were found to be HIV positive, and they were still working as doctors. In fact, they were even operating. So a health worker reviewed the information to a tabloid, and they were going to publish. Typically, they will call the doctor to pick their comments. So the doctors got the information, and they sought an injunction to prevent it from coming out. Now in court, the media houses said there's right to freedom of the press, so they should be allowed to, and that is in the public's interest, so that you know that your doctor has HIV, so that you know what to do, how to protect yourself, whether you even want to go there. Now the judge also said, look, these doctors have it, but they are taking the medications to suppress the viral load or infectivity. They are being counseled, they are taking all the cautions, and therefore the risk of transferring it to another person or infecting a patient is so minimal. And therefore, if you still go ahead, it means health workers should take note that once you get it, or if you're a doctor and you get it, and you allow it to be known, it will come out. In that case, they won't come out to do the test. So she balanced this and said, no, it should be injuncted, the story should not come out. That's the case of X versus Y. So the balancing act is done so that we make sure that the overriding interest of the public, if it calls for such breach of confidence, is done. Other than that, it shouldn't.
You earlier mentioned the RTI and other laws that can maybe allow you to get information when you need to do that. Now, even getting information, I want to find out, maybe in a typical case of maybe a law case, we're in court and there is a case that will need certain information, but it's in confidence, and you are called into court as a doctor, but that information you have would help the case. Where's the balance? How do you do that? Is it something the court can easily compel you to even share when you are not even supposed to do that?
Yes, this is a very important one. The court can compel you. Like I said earlier, health information, medical information is not privileged.
Okay.
According to our Evidence Act, Section 103, it's not privileged. So the court can compel you to, if it is in the interest of the public to do so. In fact, there's a case, Hunter versus Man. The doctor treated two guys who had done hit and run. They hit somebody on the street and they ran away, but they were treated. They got injured, so they were treated in the hospital. So the police approached the hospital for the doctor to give the address and identity of these guys you just treated. And the doctor thought it would be a breach of confidentiality. He was convicted, and even on appeal, he was still convicted. The reason is that you were being asked to do so by a lawful authority, either the courts or the legal institutions. In that case, it has to be revealed, or confidentiality has to be breached for a greater purpose or for a greater interest.
Yeah. Now, to avoid, for instance, the situation of what I asked earlier about whether or not we should know what happened to our late former president and things like that, is it, and we don't do a lot of that yet, that's why I'm asking this question, is it time for instance, our political leaders to openly declare what their health statuses are, so that in the events that there are incidents like these, they would know? There's a recent case of the late former MP for HSO and things like that. There are a lot of these cases. Sometimes we'll ask, but because you're a non-direct family, you never get to know. Do you think it is time for our politicians to be telling us what their health statuses are?
It is time, and I totally agree that when you are being employed, even ordinarily, there are medical tests to help declare your fitness for the job. Our leaders are employees. The country or the public has employed them to do some jobs, and it can be tough. Our current president has said sometimes he works all night. It takes a lot of stamina to do the kind of things they do. So generally, I am for the call that we should have a way of declaring fitness. And this is also supported by the Constitution, and I know other authorities which have said so. But there are practical difficulties.
What are the difficulties?
I'll tell you. Now, you have a party goes to a conference to elect a flag bearer. And we all know what goes into this. The amount of money spent, the stakes here. So at the very final stage, and then somebody declares them to be unfit. The practical difficulty I see here is who is going to be the person to determine or to declare this fitness or unfitness. As we speak in Ghana, we do not have an independent, say, office when it comes to health. Because the Minister of Health, which appears to be the highest body, is an appointee of the president. Kwelebu CEO, Confidentiality CEO, the other CEOs, the government has a heavy hand in their appointment. So assuming truly an opposition leader is truly not fit, and any of these appointees come out, let's say 2016, and any of our CEOs came out that, let's say, Kufuor was unfit, you can imagine what would have happened in Ghana. Or in this current election, and somebody says that President Mahama is not fit. You can imagine what happens. And can the same hospital, let's say Accra, regional hospital CEO, or any of their CEOs, can they even say that Bawumia is not fit? Will it even be believed? So we don't have an independent office yet. The Ghana Health Service should have been an overall as a head when it comes to the hierarchy, so that probably the Director General could have been in a position to issue something of the sort, at least a certain sense of independence, so that it could be believed. So now there are practical difficulties in doing so. Though what I may suggest, however, is at the flag bearership level, at the party level, for those who submit their need for flag bearership, probably they should ensure some medical assessment to declare their fitness.
So that means at least at the level of maybe executive, they should be able to let out some of information like that, just so your executives know. Are you speaking about maybe at the level of a party?
At the party level.
Okay.
At the party level.
But not for the general consumption, for maybe like you and I, who are not necessarily there. Now,
when it becomes part of the requirement that your flag bearers that you are submitting, the list of flag bearers being submitted to the EC have been declared fit, at least it covers it all.
Okay.
So that we know that whoever is contesting is fit.
Can you lose your license for breaking this confidentiality?
Yes, you can. If you do so,
like that?
If you do so, it's unprofessional. It's a professional misconduct. And I've enumerated some of the consequences when it's broken. Clients may lose confidence in even approaching the health facilities. So yes, you can lose your license. And that's the jurisdiction of the Medical and Dental Council. Patients who have suffered similar breaches can approach the Medical and Dental Council. They are doing a wonderful job. They will look into the matter, and if there should be any sanctions, they will apply.
All right. Dr. Edward Ado Dankwa, thank you very much. This has been an interesting conversation. Medical confidentiality. And even before we go, I just want to find out whether there are a lot of people who actually know about such things as medical confidentiality.
I would say no. Unfortunately, in our system, not many are informed. And at times, I put the blame on the health workers. At times, we are unable to have more time to educate our clients, especially when it comes to these HIV issues. I had a patient who tested positive to HIV, and she said she doesn't want her husband to know, and was pleading with us to keep it in confidence. Apparently, she knew the husband more than us, and she felt when she reveals it, it may lead to violence, she may be attacked, divorce, etc. Now, when it comes to that, what we do is to, again, do the balancing. Now, when a man has HIV, it's almost automatic to give it to a woman. By the first, second, third sexual contact, it's already passed on by way of our anatomy. But when a woman has it, again, by way of our anatomy, it's difficult for them to give it to a man. And when she agrees to take the medications, it further suppresses the viral load, and therefore it makes it very difficult to give it to a man. I had such a patient, and for about 10 years, she kept on taking the drug. She was fine, she was good. And finally, the man discovered it. He saw the drug and he goggled and asked her, what drug is this? And she confessed. So you could imagine the mood of the man. He said for about 2 weeks, the man even left the house, was not talking to her and all that. But later, the man came. Apparently, he had gone to do the test himself and realized he was still negative. So he came back and even patted the wife for taking the drug to protect him.
All those years. Yeah.
So what we say is that when, for instance, a woman is found positive, the priority should be on encouraging her to take the drugs, not going behind her to disclose to the husband or compelling her or coercing her to go and disclose to the husband, because that may bring trouble. And according to the Ghana Youth Commission Act, that should again not be the priority, but get her to take the drug. If she wants to disclose, that's fine. But where she says she doesn't want to disclose, you do not push her or go behind her to do so. It could lead to loss of confidence.
All right. Thank you very much, Dr. Edward Ado Dankwa. He is a lawyer, a senior medical practitioner, and also a medicological practitioner. Thank you, sir, for the education on this very important subject of medical confidentiality.
Thanks so much, Eche.
All right. So thank you very much for joining us. This has been the Lowdown here on GhanaWeb TV. I sat in for your regular host, Daniel Odro. Until another time, be kind to one another.